Now, most of you who follow my diary and who look at some of my videos on YouTube will, of course, know that I act for Mr. Charles Richardson and Mr. Frankie Fraser. Now, Charles Richardson is commonly called Charlie, and Frankie Fraser is dubbed Mad Frankie Fraser, but let me tell you, he's not mad at all. He's far more saner than a lot of people there. Now, some will remember that in 1967 they faced what was then commonly called the torture trial of the century. There were many, many allegations against Mr. Richardson. He was a South London gangster that apparently intimidated all and everybody of that. Well, the reality of the situation, of course, was that he was a businessman. He may or may not have done things, perhaps not absolutely legal, but he strenuously denied that there was any violence whatsoever on anyone. There's a film made about him recently called Charlie, and I strongly suggest that you go out and get that and see that. It's somewhat of an accurate picture. But this is about the trial process before Mr. Justice Frederick Lawton. Well, Mr. Richardson and Mr. Fraser and the others that were indicted and sentenced to long terms of imprisonment at the time, 25 years for Charlie, certainly always screamed their innocence. They were never able to actually prove it. Well, I've been able to do that because, thanks, well, I'm not going to say who to, but I have the documentation which certainly showed that as a matter of law, he didn't get a fair trial, and that's all you need in England. The conviction has to be not safe. Is the conviction safe? In the case of Richardson and Fraser, no. Why? Well, you may laugh. It's because, frankly, they were not produced in court. Now, how could we prove that? Of course, I had to go and use some pretty good influence in getting the file which the Lord Justice of Appeal, Edmund Davis, actually had. And I've got it here, of course. And don't ask me how I got it, but I just got it. And anyone that knows anything about the law, of course, knows it's a prerequisite that at trial or on an appeal, you have to be present. And if you're not present, then you have not had an effective appeal. And here we have a situation where it's very clear, and I want to show you some of the documents here. If you see here, for example, here you will see the file note from the Court of Appeal, whether or not appellants are to be brought, and here it says informed not to be brought. Now we go to the next one there. These are the papers, as you can see, of Lord Justice Edmund Davis. They're his papers there. And look what's on here. Torture case. If ever there was anything like that, it's absolutely scandalous. You then move on to the file, and thanks to Mr. Rogers, these documents are to preserve, not to be disposed of without authority of registrar. And again, here you can just see torture and conspiracy case. Now, it's interesting to know, of course, that there was no conspiracy, because no conspiracy count was ever added. And here, you have it here, the complete files in torture and conspiracy with Mr. Hunt, head clerk. Now, I have written to the Lord Chief Justice, Lord Phillips, and said that this is nothing short of scandal. How can the Court of Appeal have documents on this? How can you head a file, torture and conspiracy when there are no conspiracy charges? How can you deny the people the right to be present in their appeal? In my view, as I have submitted, this conviction is wholly unsafe on proceedings.